My name is Trevor Copeland. I serve on the board of the Chicago Lawyers Chapter of the Federalist Society. Our chapter is actually celebrating its 25th anniversary this year, and this is another in a series of presentations that we more commonly present on a quarterly or semi-annual basis. But we're very pleased to have a great event for you this evening. I think you're going to walk away learning some new things, seeing some different perspectives than perhaps you have about the First Amendment online, search, privacy, and personalization. We've got an excellent panel of distinguished speakers who will, in classic Federalist Society tradition, discuss and debate these topics over the next hour or so. If there's time left at the end, we will open the floor for some question and answer, and we'll have people circulating with microphones. A few logistical items. We have applied for CLE. The MCLE board has not yet certified that, but on the back table on that side of the room are the CLE forms. Pick that up, take it with you if you would please, as long as you provided an email address at registration. I will email out everyone who provided that and make sure that you get, one, a copy of the bibliography, and two, a certification that we actually did get our CLE credit, which we anticipate doing. I would like to thank the National Office of the Federalist Society as well as its practice groups, in particular the IP practice group, the litigation practice group, and the corporations, securities, and antitrust practice group all contributed to bringing together this event this evening. I'd also like to thank my colleagues here at Rinks, Hofer, Gilson, and Leone for hosting this event, and in particular Ms. Tracy Rudd, who you saw at registration, who has been invaluable in helping me to pull together this. Providing the intellectual meat of this evening's discussion, we have an august panel of speakers who I would like to briefly introduce. Each of these individuals has an illustrious resume. We could actually spend the next hour just rehearsing their curriculum vitae, but I'll try to keep the introductions brief so you can listen to them shortly. Speaking first will be Professor Richard Epstein. He is the inaugural Lawrence A. Tisch Professor of Law at NYU Law School. Prior to his joining the NYU faculty, he was the James Parker Hall Distinguished Service Professor of Law at the University of Chicago. These are only his most recent professorial endeavors, as he has been engaged in being a law professor since 1968. He did his AB at Columbia College, BA at Oxford, and his law degree at Yale. There is a more extensive copy of his bio on a handout that is also backed by those CLE forms if you'd like to see the veritable A to Z of law courses that he has taught and written upon. Next, we have Baron Soka, who is the president and founder of Tech Freedom. Previously, he was a senior fellow and director at the Center for Internet Freedom at the Progress and Freedom Foundation. Before that, he practiced communications law and clerked for Judge H. Dale Cook of the Northern District of Oklahoma. He earned his bachelor's in economics from Duke and his JD from the University of Virginia Law School. Professor James Grimmelman is an associate professor at New York Law School and a member of its Institute for Information Law and Policy. He earned an AB in computer science from Harvard College and actually worked as a programmer for Microsoft before earning his law degree at the Yale Law School. He clerked for Judge Marianne Trump Berry of the United States Court of Appeals for the Third Circuit. As both a lawyer and a technologist, he works on getting folks who specialize in law and technology to talk to each other in a more intelligible fashion, ideally. He writes extensively about intellectual property, virtual world search engines, online privacy, and other computer and high-tech related topics, as well as having developed a leading expertise in the Google Books settlement. Professor Jonathan Macer is an assistant professor of law at the University of Chicago Law School, before which he taught there as a Bigelow Fellow and lecturer. He earned his BS in physics and an AB in political science from Stanford University, and his JD is from the Harvard Law School. He clerked for Judge Richard Posner at the U.S. Court of Appeals for the Second Circuit, as well as Chief Judge Marilyn Hall Patel at the U.S. District Court for the Northern District of California. Finally, and certainly not least, I am very pleased to introduce our moderator for this evening. Judge Diane Wood is a circuit judge here for the United States Court of Appeals for the Seventh Circuit, as well as a senior lecturer at the University of Chicago Law School. She earned her BA and her JD at the University of Texas at Austin. She clerked for Judge Irving Goldberg on the Fifth Circuit Court of Appeals, as well as for Justice Harry Blackmun on the U.S. Supreme Court. She was a deputy Assistant Attorney General in the Antitrust Division before being appointed to the Seventh Circuit in 1995. She is also a fellow of the American Academy of Arts and Sciences and is on the council of the American Law Institute. So she will be moderating our panel this evening. A final logistical note and a little bit of promotion for our chapter. The Chicago Lawyers chapter of the Federalist Society will be presenting a lunchtime event 1 week from today featuring Ramesh Panaru speaking on the future of conservatism. Our Facebook site will have that, and if you, I'm sure by the close of business tomorrow, if you Google the event, you will definitely be able to find it. So without further ado, I will turn you over to Judge Wood. Thank you.
Well, thank you, Trevor. I think we've actually already heard a little prelude of the kinds of issues we have, because he mentioned the year in which Richard Epstein began to teach, which begins to tell you something about Richard. The topic that we have for this program is one which is of intense interest, certainly to me personally, because it really requires an amazing blend of expertise about technological developments, about legal theory, about what it is we think we are doing in terms of a variety of doctrines. And our panel is going to be focusing, as the program tells you, on, I'll just say generally, the privacy aspect of the online world. There are other aspects we might have thought about. We might have thought about defamation. We might have thought about different sorts of, criminal law measures, but we are going to try to focus in this way, and you're going to see some people who will take a very broad view, and then some people who, as I would like to say, actually know about this stuff, who are going to give us a much more detailed glimpse of what it is we're dealing with. I myself am certainly looking forward to the discussions and hope that I will take away something. I assure you the courts are already seeing cases that present different aspects of these issues. And so without further ado, our first speaker is Richard Epstein.
About 10 minutes or so?
About 10 minutes, yeah.
Okay, thank you so much. I feel exceptionally conscientious today. Before I came here, I actually read for the first time the FTC Do Not Track proposal and the Second Circuit decision in the IMS Healthcare versus Sorrell situation. So when it comes to particulars, I'm loaded for bear. But the question here is, I think I'm one of these broad people, by which we mean I'm supposed to sort of set the general framework by which we would want to evaluate the privacy situation. And so I'm just going to do one or two preliminaries in order to do that and then give a more concrete version. First of all, as Diane mentioned, privacy is a hydra-headed monster which has many different parts associated with it. And the question is, which of these parts are we putting to one side? The first part, which in 1903 was part of privacy, is all of the misappropriation cases of using name and likeness and so forth. Those are commercial cases in which the issue is not whether you keep something private, but who makes it public and draws the remedy from it. Not our concern in this particular cases. Defamation having to do with falsehood is again another issue which certainly has to do with reputation and with freedom of speech, but we're not talking about that. We're talking here about essentially another form of privacy. Which form? The traditional literature decides between decisional and informational privacy, terms I don't particularly like, but they're in the literature to stay. And by informational privacy, we mean is the ability to control information about yourself, including stuff which may be adverse to you or may be useful to you. Decisional privacy is, again, not part of this situation. That has to deal with such things as the right to have an abortion on the one hand, or various kinds of personal decisions free from the intrusion of the state. So when you're starting to talk about this decision with respect to privacy and informational privacy, the simplest question you want to ask is, if it's a troublesome area, it's got to be troublesome because it's going to have to butt up against something which is going to propose various kinds of limitations on the way in which it's going to be used. And when I see sitting next to me Mr. Zoka, who starts talking about tech freedom, and knowing his association with the Progress and Freedom Foundation, now defunct, it's also very, very clear that one of the problems that you have in this area is the way in which you try to organize a system of privacy in a world in which we believe that public information should be previously or freely generated. This is not a new issue when it comes to the internet. If I happen to see you walking down the street, I'm entitled to comment about that to somebody else, even if it turns out it's an untoward neighborhood. But on the other hand, generally speaking, I'm not allowed to go through your files to find out which prescription drugs you're taking, because there is a sense of an expectation of privacy, which is shaped not just by some abstract notion, but by the general rules of property. Because if you remember, the original law of privacy as it developed was an extension of the law of trespass. Such things as eavesdropping, which were not direct entries, were nonetheless thought to be close enough to invasions that they were to be treated by the same kinds of rules. So it's always the conscious applications between the two of them. And that's on the liability side or on the entitlement side. The second part of the problem that one always has is what's the nature of the remedy involved. And this in part is going to depend upon what you perceive to be the various values of the interests that are at stake. And when we organized our little discussion of this panel, what I stressed was that if you start to think about privacy in the way in which many advocates talk about it in the general world, my deep unhappiness about this is twofold. One is that I think they tend to overrate privacy as an interest by the sense that they assume that people attach more weight to their privacy under many circumstances than they actually do, and that leads them to develop rules which are, in fact, much too limiting on the way in which information freely moves and flows. The leading illustration of that, which I think now commands fairly wide consent, is the so-called HIPAA statute, which was designed to deal with the portability of various kinds of insurance policies for pre-existing conditions, has become an absolute juggernaut in terms of the way in which medical information can be freely disposed of across people. And you cannot find anybody who's ever worked in the area who believes that the statute does more harm than good by essentially imposing a four-cause regime with respect to virtually all kinds of transfers of delicate kinds of hospital records and so forth. Most people, if they turn out to be in Montana and they may be dying, they would rather have somebody get instant access to their blood type for a transfusion than to have to go through an administrative hearing, which would decide whether or not under the circumstances there's a sufficient necessity to allow these things to take place. That's a bit of an exaggeration, but at the beginning wasn't all that much. And a lot of the stuff with respect to online things, I think, has exactly the same way. If you start looking at many of the situations in which you, as a company, give people an ability to withhold information from third-party vendors who might want to take it and assemble it in some way, you ask how many people check the box. Please do not put me in that group. Typically, the number is well under 1%, even 0.1%, because lots of times dissemination of information about you is something that you want rather than not want. So to give you the famous case, if you're a consumer and you have a series of patterns that can be determined by the way in which you make your online purchases with credit cards, this information is then bundled up and is provided to various other kinds of third-party providers. This is the way you think about it. First of all, you know, if you know this business well enough, that nobody who gathers this data is going to simply give it to a third person who could use it for unlimited purposes. What they will do with that information is give them, in fact, a promise that we will give you so many people of such and such a description, but not the names, because if you give it to them once, you'll never be able to sell it to them twice. And then you salt the list so as to make sure that there's not going to be overuse with respect to it, just the way map makers have always put in phony cities on their maps to make sure that they're not copied by other individuals. And then what happens is the consumer whose name is not revealed gets a subset of the useless spam that would otherwise come to him, so they get ads that they're now more willing to read, and you look around the cycle, it turns out to be win-win-win at every particular stage. So I think, in effect, that when you start to see this, your presumption ought not to be, as it is with the FTC and its general report, that there's a huge demand out there for privacy and everybody ought to gear up all sorts of internal apparatuses to do it. I think a lot of this is that the FDA realizes that they could get people to gear up for privacy. There's going to be more work for them to do, which means that I think on balance there's going to be less productivity with respect to the economy as well. And the second point that I wanted to make about this more generally is that if you start to look at this stuff, when you're dealing with privacy and with information, there is a very close parallel between the law of trade secrets on the one hand and the kind of informational privacy that people want on the other. If you look at the formal legal doctrine, the definition of a trade secret is very broad. It's basically any piece of information that is generated privately, which, if used by you alone, will give you a competitive advantage over your rivals. Now, that's a pretty broad list that covers everything that's going on. But if you actually look at the way in which companies treat their trade secrets, some of them they put into deep six, which is almost impossible to gain access to the information, and others they're willing to distribute on Xerox paper through a kind of a general mass system. Because what happens is They voluntarily segregate through self-help remedies backed by the law information such that those things which are of greatest value to them receive the greatest degree of protection. And it's not just businesses that do this. One of the reasons why the privacy thing, I think, is overrated is that if people think they do have information which is of importance to them, what happens is they don't tend to use that information in the kinds of media which are likely to be shared with other individuals. So if you look at the way, for example, that psychiatric records are treated in a voluntary market, they are always given greater care than the question of whether or not it turns out that you had your bunion removed by some kind of plastic surgery. So that the level of protection that you get through the market is essentially corresponds to the reluctance that people have to talk about things when adverse things start to happen to them, which means in effect that there's a kind of a self-selection and a self-organization. And to the extent that you do have this self-help mechanism, the right question to ask about government intervention on these circumstances is, if the self-help remedy takes you to X, do we need to do this much or that much more in order to get to an optimum level? And since you've already got some protection, the presumption would be that the amount of state intervention that you need is actually somewhat less than you might have proposed if the self-help remedies were not there. So I've already indicated to you why it is I'm uneasy about the do not track stuff. You know, I'm perfectly happy to allow people to have options so that they say that their data cannot be put into the general mix. But of course, the FTC report doesn't stop at a simple default provision one way or another. It has these sort of grand ambitions in which they assume that the presumption is in favor of institutional privacy without any demonstration that that is the case. And the other point that I'll just make, because I have about 2 more minutes, is this other case, this very interesting case, the Sorrell case. You know, you go to Vermont and we read a statute, the presumption is that you know it's a stupid piece of legislation. But that's not the same thing as saying that it's an unconstitutional piece of legislation. But the legislation involved in that case was uncommonly dumb. What they did is, in an effort to promote, so they thought, the use of generic drugs, which they thought would increase the level of healthcare, control of healthcare costs, they made it illegal without the consent of a physician, not of a patient, to take physician identifier information and to bundle it for sale to third parties, where it would then be used to allow various marketing kinds of agencies to target the kinds of sales and the kinds of supervisions to individual docs. And I think, in fact, the traditional view on this is you had the same virtuous circle that you had in dealing with the information that is given to customers. There was no evidence of any particular point of abuse. All of the data collection societies were reluctant to give you all the information in one fell swoop because they could not monitor the purchase. So you're seeing here a market failure which nobody can identify. And then the question is, how do you treat this under First Amendment law? And it's a very interesting kind of discussion because it shows you once again that in the First Amendment, categorization counts more than theory. So if you look at this kind of composite transaction and say it's commercial from top to bottom, then what you're going to have is a kind of a low standard of scrutiny, and you're likely to say that the thing ought to be supported. On the other hand, if you assume that it has to do with the dissemination of medical information of a somewhat higher value having to do with cure and help, then you may give it a greater level of protection. What I found so distressing about the statute, because I view the constitutional stuff as an add-on, is that the idea that somehow or other you will get more efficient use of healthcare resources in a state in which you systematically suppress the use of valuable information strikes me as getting the relationship exactly backwards. Generally speaking, if in fact you can target doctors, know which things work, which things don't work, and so forth, and sell in an intelligent fashion, what you can do is increase the marginal sales at relatively low cost, which means that you can amortize the fixed cost over a larger population, which means that the effects on innovation are generally going to be positive rather than negative. And one of the constant mistakes that these poor folks make is that they always assume that the only form of competition that matters in the drug market is getting generics against traditional branded drugs, where in fact the key form of competition that makes for the huge change is to have a system of institutional arrangements such that the guy who comes up with the next branded drug can be in competition with the guy who had the previous one. And if in fact you thwart the promotion efforts, in effect the gains from innovation will be reduced correspondingly. So I would have said that in chalking up the state justification, this one had to get a rousing negative rather than a positive. That probably meets a rational basis standard, at least in the eyes of some on the Supreme Court. But I do think, forgetting about the Constitution for a moment, that when you start to think about how these information flows work, you have to be extremely critical of any legislature which simply looks at one point in the process and one particular consequence and think that that's a substitute for a global analysis. So as I'm going to sit down now, the point that I want to leave you with is that you don't want to start the analysis of information flows in public networks with the First Amendment. What you first want to do is to actually understand how these things start to work. And if you could get better legislation in that fashion, you will reduce the strain on constitutional law, and you will allow Diane Wood and her fellow judges to have the principled form of leisure to which they so richly deserve. Thank you.
Thank you, Richard. So before we turn to Baron, I can't resist saying that, Richard has given us a very good glimpse of the way in which the kind of information that is collectible on the internet can be used to improve markets, not just to annoy you with all those spams that you don't want. I hesitate even to refer to this because you've probably seen way too much of it, but let's just say delicately that some people are reckless with the kind of information they put out about themselves on the internet. And we've been treated to a week's worth of bad jokes about that. And I will say, as the parent of a number of 20-somethings, that recklessness also extends, and maybe even just lack of knowledge about how much information about yourself you're actually putting out there when you have a Facebook account, or when you're tweeting, or when you are even just sending emails. The Supreme Court decided that when somebody sends emails using an employer-issued device, that's the employer's business, not the person's private business. So I think there is a question about how much, if any, paternalism is called for in this area, or whether we should just let, the Anthony Weiners of the world do whatever they're doing. But now I will turn it over to Baron.
Well, I was going to say that was a tough act to follow, referring to Professor Epstein, but I think in both senses that's a tough act to follow.
Whatever you want.
I'd be more comfortable having a discussion here. So I want to start by just saying that I'm not anti-privacy, and sometimes people who get into these conversations will tend to think about this as being pro-privacy or anti-privacy. I don't think that's the right way to think about it. I think, in fact, as Judge Wood says, one of the better ways to think about this is about paternalism and the proper role of that and the extent to which we should be paternalists. And I think, in general, I'm skeptical of paternalism, but that doesn't mean that there aren't some circumstances in which I might not argue that there is an appropriate role for government. So I first want to say that the thing about privacy that you first have to remember is that it's not a monolith. It's a complex of many thorny problems, some of which are very different from each other. And so I think that both of them are exactly right, that you really have to think very carefully about the particular circumstances you're dealing with and ask about a principled approach. And I think that's what I'm going to try to articulate today, and that I have done in my work in this area for the last 3 years. So the other thing I would say by way of background, as you already heard, I started working in the think tank world, having left private practice at the Progress and Freedom Foundation, which had existed since 1993, and whose mission it was to study the digital revolution. And it occurred to me in preparing for this panel and thinking about how to unify the theme today, that really the work that I now do, the work that evolved when I was at PFF and that I now do at Tech Freedom, which in some sense has succeeded PFF, is really to work on the personalization revolution. And what I mean by that is that both search and privacy and all the issues that we talk about today really are about that next generation of not just digital media, but media that is really personalized and attuned to us. And it's not to say that that hasn't happened in the past, because of course it has. And in fact, all of the history of media is in some way an increasing, a story of increasing personalization, but obviously it's taken off exponentially. And if you just want to think about the growth factor of how personalized media is, that clearly is fundamentally different today than it was, say, in 1993, and even than it was, say, 5 years ago. So it's in that sense that I think about personalization as being a wonderful opportunity, but also something that does present real concerns, and I'm not insensitive to those, but I do think that there is a certain fundamental conflict of visions that plays out here, and I have in mind, when I say that, Thomas Sowell's typology, and I won't belabor with you the details of that, but I would simply say that there is a range of perspectives on this, and most people are somewhere in the middle, but But at least on one end of the spectrum, there is what we'll call the unconstrained vision, which basically in general doesn't think about trade-offs and thinks about fundamental rights and likes to talk about privacy as a fundamental right, and a right that in Ronald Dworkin's terms trumps mere economic interests. So in other words, when you say, well, look at the costs of regulation here, the response either implicitly or explicitly is, but it's a fundamental right and we have to protect it. And you see this very clearly and explicitly in Europe, although not so commonly here. And that view of privacy is one that tends to think about privacy in terms of personal information that is owned by us much as we might own copyrights. And in a nutshell, it boils down to essentially saying that users must opt in to having information used about them, or that the information can never be used because it's just too sensitive. And then on the other hand, there is where I come from, which is what Sorrell would call the constrained vision, which basically thinks that privacy is one of many competing values, and it's an important one, and in some circumstances it's extremely important. But again, there are many competing values, and in this case, that is not just mere economic interests, as we talked about, such as creating revenue for media by advertising that is enhanced in its value by the data that is provided about users' interests, but also the innovation that comes out of that data. And for example, that includes things like the ability to predict in real time where flus are breaking out across the country based on looking at search logs. Great example of innovation that is not about creating wealth necessarily, but about enabling us to better understand the world around us. But also about speech and observation and our fundamental right, as Professor Epstein was saying, to observe the world around us and to make statements about it and message both to sell commercial products and also to sell non-commercial messages, political candidates, and so on, to our fellow citizens. So it's in that sense that I think that data really is the new wealth. And I was walking around Northwest Campus the other day and saw on the School of Industry, I think it was, a great quote from Edmund Burke that sort of summed up how one might think about this, which was that if we command our wealth, we shall be rich and free. If our wealth commands us, we are poor indeed. And I think that probably everybody in this context would agree, in the privacy context, that there is great wealth to be controlled here and to be gained. And the question is, how much do we risk losing from regulatory intervention? And what does it mean for us to control our wealth? And I would say that there are probably two biases in this debate. And the first is that people tend to dramatically underestimate how much wealth, in the sense that I've just mentioned, innovation, speech, all those other things, in addition to mere economic interests, there is to be gained from the personalization revolution. And second, to Judge Wood's point, they tend to fundamentally underestimate the extent to which self-help really works and the extent to which user empowerment is an option. So in a nutshell, my approach, the approach that I've articulated for the past few years, has been to say that we should always look for a layered approach of less restrictive alternatives to deal with real problems. And that should begin with technological empowerment as well as education, because I would strongly agree that people probably don't understand well enough how, what their information is being used for and how to manage it. And Facebook's a great example of that. We could talk about that in Q&A. But my answer is not to rush in the first instance to prescriptive prophylactic solutions, but to ask whether we can build tools that empower users to make decisions for themselves. And then the role for government would be to look for areas where users really can't make those decisions for themselves, where there really is some failure, and to say that in essence, that our fair information practice principle, which is what's always debated in the privacy world, really should be the First Amendment, because the First Amendment not only is our constitutional doctrine that governs how we deal with the flow of speech and data, but it also lays out what I think is a pretty good test for dealing with regulatory intervention, which is there a compelling harm? If so, is there a narrowly tailored solution to it? And are there less restrictive means of dealing with it? And I think if you take that approach, you actually can have government intervention, for example, in punishing unfair and deceptive trade practices. That's something that I generally think the FTC should be doing and indeed could do more of in the privacy context. And we could look for other potential opportunities for intervention. I'm not saying that everything they do is good, but for example, just to give you one concrete instance of what I mean, they hold people to their companies to their privacy statements, but they've never enforced the machine-readable, machine code privacy statements that companies are supposed to make that translate their human-readable privacy policies into a more robust form that can be translated by user empowerment tools. And I think that's a mistake. That's something that the FTC clearly should do. So I only have a minute left, so I will just say in closing that these fights are going to come out in First Amendment doctrine in the next decade. And the Sorrell case that Professor Epstein mentioned is really just the first of them. We filed an amicus brief both at the Second Circuit level and before the Supreme Court. we were standing up for the free flow of data. In other words, we were arguing that the state was on the wrong side in trying to suppress information for clearly paternalistic reasons, but that more fundamentally, what the court really needs to recognize is that the data that was flowing in those cases has to be protected as speech. And then just to leave you with one final thought, that even if you buy the distinction between intermediate and strict scrutiny for commercial and non-commercial speech, which I don't, but even if you do buy that, I think that distinction starts to break down when you see the fact pattern moving from cases where you have a single website that is either clearly commercial or clearly non-commercial, such has been the case with previous regulations of the internet. You move from that situation to a case where instead, today, you have what I would call online speech platforms. Search engines and ad networks are two great examples. And those are platforms that use the same set of data to tailor and deliver and personalize both toothpaste ads and political candidate ads. And in that sort of circumstance, where regulation that says that you can only collect a certain set of information if you, for example, specify its purpose, you burden both, in the end, the personalization of non-commercial and commercial speech. So I would just say that, again, it's not that the government can't regulate those things, but the courts really need to recognize that they are ultimately regulating speech when the government regulates privacy and the collection of data, and to look for a principled way to do that. And I think the First Amendment has already given that to us.
Thank you. And just to put it in its most stark form, we are talking in part about whether there will be prior restraints on certain forms of speech, which many people have understood to be the core of the First Amendment. There are many other things one could say about Facebook as well, but I'll just say that, interestingly, if you followed it, it's an example of a private market adjusting and readjusting to privacy expectations of the users. Sophisticated users have objected to the degree of openness from time to time, and Facebook's gone back and renegotiated, and then there have been other objections. So it's actually been a dynamic process, not at all a static one. But let me turn over to Professor Grimmelman now.
Thank you. I had originally planned to say some things about search engines and about how their rankings are shaped. But I think I'll take the perhaps ill-advised step of saying a few things about privacy instead, because I think that Professor Epstein's and Barron's remarks really flow together towards a very important theme, which is the degree to which the law enforces a kind of control, we could call it, or empowerment over personal information. That is, the degree to which, by controlling and restricting the flow of it, it can also, to some extent, empower individuals to see that it's used in ways that they prefer. So I want to make 3 points that connect that. The first has to do with the degree to which companies that are using this information for the purposes of targeting speech and marketing regard control as an utterly important part of their business models. Professor Epstein referred to this when thinking about companies that will never share their full lists without the dummies to track to make sure that they're not being used to market more extensively than they agreed to. But you see this a lot with web tracking information and with purchase information, that everyone wants to be the business that has control over that database. So, for example, the credit card companies are insistent that they control their central database of numbers, and the merchants not use that purchase transaction information for their own targeted marketing. This is why your supermarket has a discount club card that you want to scan when you go to the registers. It's so that they have their independent source of data tracking you. And in a similar vein, one of the reasons that publishers were upset with Apple's plan to control all of the subscription revenue through subscriptions on iPhones and iPads, the 30% cut that Apple was demanding was actually a less significant issue for many of them than the fact that all the purchases were going to go through Apple, and that Apple would have the persistent relationship with the user and would have the data that could be mined and extracted and used for more effective recommendation of other things. And the publishers wouldn't have that long-term tracking relationship at the purchase level data that Apple had. So this is commercially remarkably valuable, it has many uses, and the companies regard control over it as very important. So the second thing I want to discuss is the degree to which certain interventions or certain technical systems can enable effective user control. And here I think Facebook is a very great example, because it's a system that has been, in many ways, systematically designed to make people misunderstand the privacy consequences of what they do. And when people do manage to figure out the rules, Facebook changes them. It has a long history not just of being more open than users want it to be, but unexpectedly changing the privacy consequences of things that users had already done in ways that increased the visibility of data to other users without effective advance warning. And the policy is they do this, and then there's an outcry, and they back off and they say, okay, we'll allow you to opt out of this feature, or we'll step back and roll it again. But they have half a dozen times fallen into this pattern. And I think this points at one of the major reasons people are often, we might say, careless about personal matters, large and small, everything from just the basic transactional matters to the ones we've just been hearing about with our elected representatives.
Large and small.
I was so not intending that. But that one of the reasons people feel a sense of haplessness and futility is simply that there are so many sources of information that trying to catch and keep track of them all is an exercise in frustration. If you make even a few mistakes, the cat is out of the bag, the pattern's been established, you have been linked to this profile, and people know that in fact any individual decision is not going to have a significant effect, and that because it is so hard to track where they appear in the databases that these companies have maintained, precisely because these companies regard control over the databases as commercially valuable, it's actually extraordinarily hard to figure out what the privacy consequences of your commercial actions online have been or will be. And so this brings me to the third theme here, which is the do not track proposals. And this is in some sense very much about default setting. Do consumers need to opt in to tracked marketing the way that opting into your supermarket rewards club is a kind of opt-in system? Or do they need to opt out by clicking that box and saying, no, you cannot use this information for purposes beyond this specific transaction, and to be careful to click that opt-out box each time they engage? Well, one way of setting the defaults is through rulemaking and to say that this is the default and will be going forward. Another way of looking at the do not track proposal that I think is very encouraging, actually, is to say that by giving users the technical means to make a preference known in a general basis across a wide range of transactions and websites, it facilitates more flexible default setting. It facilitates consumer setting a default on a per-consumer basis rather than a per-population basis, with the ability to opt in and out for particular transactions. And so in that sense, relying on this signal, the message that you send to the website as a way of indicating what the rules will be is in fact a more control facilitating, easier to take advantage of system than rulemaking as a flat default. So this is control facilitating legislation, one might hope, in some of its better forms. There are less good ones on the table as well. And I'll close with a perhaps radical suggestion, which is that we know about the mass market browse wrap, click wrap terms of service, where the company's website has a statement on it, and you click to agree when you agree to those services. One way of thinking about some of the do not track proposals, the browser headers that are sent from your computer to their server whenever you request a web page, is to think that if your browser adds the do not track me header to each message, perhaps you have proposed a contract to the company, one that it agrees to honor by returning a web page to you and doing business with you at all. So perhaps this is actually facilitating a common law contract process that is, we would hope, maximizing the joint gains from both parties to it. Thank you.
Thank you very much. And I'm just going to put on the table for future thought when we're in the conversation the question of what I want to call retrospective control that I think came up. You know, information got out there and then there's some reason to look back. We, of course, see the very dark side of this in the judiciary when information is out there and then somebody decides to figure out where you're living and bomb your house or, put a lien on your house or kill your husband or other sorts of things that have happened. It turns out to be very difficult to purge information about yourself from the internet. But the more general question, even in a more benign way, might require us to think about looking back as well as forward. So we'll give you the rights to wrap up.
Okay. Thank you very much, Judge Wood. So I guess I have just a few brief points, which I think will, to some extent, both synthesize and also take issue with the comments made by the earlier panelists. So, I think what's important to emphasize is that the starting point for this entire analysis is that people want to control the information about themselves that's being released to the public, no matter what the form, no matter what the medium. Sometimes they want to share it. You want to project an image of yourself through the website you maintain or through Facebook or whatever else. Richard points to the example of someone traveling in Montana who wants his or her medical records shared. Sometimes you want to protect it. You want to guard your emails or whatever else. But regardless, you want to control it. Each individual wants to be the person who has the power to either release or control that information. And it's going to be very highly context dependent what they want to do with it. I want my medical records shared with the doctors in Montana. I don't want them shared with my next door neighbor. And I want to be able to put in place a whole set of protections that will allow me to accomplish the former while avoiding the latter. So as Richard alluded to, and as everyone knows, I'm sure, if we don't have legal mechanisms to help with this, people are going to engage in self-help as an alternative. So the more that I feel as though electronic records are out of my control, the more I'm going to resist putting them into electronic form in the first place. The more I'm worried about Facebook's privacy settings, the more I'll resist starting up a Facebook page in the first instance, etc. And as is been well understood to be the case in a lot of other areas of law, when people engage in self-help, that can be very costly. We don't like it when everyone's sort of building high fences to suppress information we'd much rather have them share with the world. This is a large part of the reason for patents, as I'm sure many of the people in this room are familiar with. We'd much rather have people sharing information around with legal protections than building fences and blacking out windows to engage in physical self-help to keep their secrets to themselves. Okay, so with the background of this sort of desire for control, I think that the first cut at the question, maybe the starting point should be, under what circumstances shouldn't we have something like either an opt-in or an opt-out system? And there are obviously large differences between opt-in and opt-out, which James alluded to. I'll bracket those for a second. Why wouldn't we want legal rules that basically allow everyone an opportunity to either opt-in or opt-out of sharing whatever information about themselves is created in any of these mediums with the rest of the world? And I'll reference Judge Wood's point about retroactive issues. Suppose I release something out into the world, maybe we ought to have an opt-in ability to take that back afterwards if we think that it's gone too far. So under what circumstances would we not want people to have this sort of opt-in or opt-out control? What are the countervailing values that might lend us to believe that there are certain circumstances in which opt-in or opt-out is either too much or too little? Okay, so one first possibility is the availability of great social gains, real advances to social welfare, if information is shared, gains that could not be achieved if we have an opt-out or an opt-in mechanism that people are really taking advantage of. So Biren mentions the possibility of pointing out flu outbreaks by tracking information about who is searching for what in what context. So that may be an option. But even when we have possibilities for large social gains like that, there are sort of privacy minimizing and privacy maximizing ways of going about it, right? There are, of course, ways of learning the information that's important, namely the flu outbreak, without actually attaching that to individual people. It might also be that people will really differentiate between sharing information with the state and sharing it with corporations. People are probably willing to tell Google and Facebook all sorts of things that they wouldn't want their governments to know about, and quite understandably. So there are presumably lots and lots of ways of narrowing the information that's shared in ways such that the value is still gatherable, but the privacy implications are not quite so great. So Biren mentioned the possibility of the most narrowly tailored regulation. You can easily think of the most narrowly tailored sort of information forcing rule, also one that releases the information without releasing all of the accompanying personal information. A second countervailing issue might be citizens' inability to choose. We might think that people are going to make systematically wrong decisions in the market about some type of information, and so we want to actually bar companies from asking for their assent, or bar governments from asking for their assent to collect information, or something like that. This is certainly possible. I think probably most of us are going to be skeptical that there will be contexts in which we really can't trust people to make reliable decisions about their own information, particularly because, now I'll get back to this for a second, the large differences between opt-in and opt-out systems, right? An opt-in system really requires someone to have actually made an affirmative choice, and and we have lots and lots of studies showing us that opt-in systems are used much more rare. That people opt in very rarely compared to an opt-out system, which very few people opt out. I guess what I mean to say is that these rules are quite sticky. So in an opt-in system, we can have confidence that the vast majority of people who are actually choosing to opt in are doing so for some sort of cognizable reason. And then lastly, and perhaps most importantly, there's the issue of speech. So of course, one very important countervailing consideration to all of our desire to control information is the free speech rights of others. So somebody writes an article about someone else online. We don't necessarily want person number one to have a right to opt out of being written about and take the article down. Somebody appears in a court case. We don't necessarily want to have person one to have the ability to remove their names, strip it from the judicial proceeding. So certainly there are important free speech considerations that weigh against sort of our general desire to control things. I guess I just want to say two things about the speech issues. One is that what we think of as speech promoting rules can often be speech preventing rules all at the same time. So imagine a rule that said, I think this is the current rule, that every published opinion, every trial transcript of every judicial proceeding in the United States is made available electronically online at all times. On the one hand, we might say this sort of allows information out, generally speaking. People can learn about what's going on. We feel that information might have value. On the other hand, this is going to dissuade people from wanting to testify in cases, to have their names appear in judicial proceedings, to put their names down as witnesses, to appear in open court, and so on and so forth. In all sorts of circumstances, it actually might suppress the speech of these individuals because of their inability to remain anonymous. On the other side of things, we have very strong anonymity protections that we have built into the law legally in the First Amendment context, particularly on the internet. There's no such thing as sort of an organic First Amendment position when it comes to internet speech. We've written laws like the CDMA that allow protections for people who want to speak anonymously. So you can run a website and have a comment board and have lots and lots of anonymous posters to that comment board, and the website, cannot be sued for defamation as a result of what people have written, and the posters who have written these comments, of course, can't be found often because they are anonymous in the first place. We think of anonymity in this regard. We might think of it as a speech promoting rule. It can also be a speech limiting rule because, of course, the people being spoken about might in some sense be themselves inhibited from engaging in speech actions of their own. So I guess the most important thing I want to say is that there's no zero position or no neutral position when it comes to the First Amendment. There is no position of zero state interference. We are already engaging in quite a lot of state manipulation of internet privacy and internet rights, and that will have speech implications on both sides of the equation.
Okay, thank you very much. Well, I would now invite, after these very provocative presentations, you to offer comments. I will just ask you, if you are commenting, try to keep it within some kind of reasonable range. And if you have a particular member of the panel that you are directing a question to, then simply say so. Should they say their name too? Is that normal?
Well, it's a privacy issue.
Say your name as well and your affiliation. So I will invite questions or comments. I'm not going to believe it. Yeah. Okay.
Mr. Applegate.
Please.
Thank you. I have a comment, and my name is David Applegate. I'm a member of the Chicago Lawyers chapter of the Federalist Society. Liberals and conservatives famously disagree on the definition of rights, and I don't intend to go into that here, but it seems to me that privacy, properly understood, is less a right than an expectation. And I would suggest that in the evolving area of electronic communications, people who actually think about this, and many people obviously don't, will understand that virtually anything that is done wirelessly is essentially out there for the world. It's one thing to send a sealed letter to a friend, a confidant, a lover, a relative, and expect the Postal Service or anyone else not to open that and to intervene in the transmission. It's one thing, we all know, to have a conversation on a landline telephone where wiretapping statutes prescribe certain restrictions before the government or anyone else can have access to that. But virtually everyone who has grown up in the electronic age, and anyone who uses electronic media or has shopped online or uses a CTA card or uses a preferred shopper card, knows that information is being transmitted essentially instantaneously to the commercial sector out there. And one should reasonably infer that that information is reasonably accessible on a showing of proper need to the government. So I would suggest that this is an area in which we should simply let the market work. And people who have loud telephone conversations on public transportation on their cell phone are going to understand that that is not a private conversation. People who transmit personal pictures of themselves on Twitter should have no reasonable expectation of privacy. And it seems to me that eventually this problem will solve itself.
All right, Richard.
Yeah, no, I think it's a bit more complicated than that. Certainly the view that if you talk loud at the dinner table, somebody at the next table at the restaurant can overhear is a norm that pre-existed Twitter. But I think that suppose you get on the cell phone and you whisper, and the question is now whether or not somebody's entitled to overhear you. You cannot treat this as simply a normative versus positive distinction, because it's quite clear, just as we have laws that prevent wiretapping, we could easily have laws that prevent you from essentially trying to tap into a conversation by a device for a conversation that you know to be made private. And in fact, we do have those laws. And the point that I made before about all of this was that you can have legal protections for privacies and differential expectations, just as you do with different classes of trade secrets, so that you give the same legal protection, but you tell people as a matter of prudence, your legal remedies are imperfect, and so therefore be careful in the way in which you segment your information. But I don't think that's an argument about rights or no rights. I think it's an argument about how it is respond to the situation. The last point I'd want to make is the notion of reasonable expectations, to my mind, is not vapid or circular. You have to understand what it is. So go to the famous case of the norms between the two tables. When we say we have reasonable expectations, we do not mean that if we know that other people are going to be snooping that we have to surrender. What we're trying to do under these circumstances is to say, look, we start with the trespass rules. And when you're dealing with common property, i.e. restaurants, tables, and so forth, they don't work. And when we talk about reasonable expectations, we mean quite explicitly, or not explicitly, but implicitly, is figure out what that optimal norm is, so that what you can do is maximize conversation by telling people this is how low you have to speak, and telling other people that they can't crane their head over to listen to somebody else's conversation. So the theory is it's an optimization game in which you try to figure out in equilibrium what is the optimal mix between self-control by those people who might be listening and self-control by those people who are speaking, such that each of them adopt the optimal strategy will have the maximum value shared by both. That is not a circular kind of statement, because it is clearly incorrect under that statement to say that when you're sitting at a table, you must reasonably expect that there's going to be a spy in the room who will have an extra sensitive microphone, so that even though you're whispering sweet nothings to your table mate in one form or another, that those things will be overheard. And what I think is so clear about this on both the auditory and the visual side is just how strong these expectations are, because the equilibrium positions are not just a little bit of a point above the thing. There's a really powerful peak. So to give you the visual version, to go back to a case like Nader, it's okay for me to observe somebody on the street. It's not okay for me to sit around there and stalk and to gare, and to stare, to follow them, to track them, and to shadow them in every way. And I don't think there's a single person in the room who doesn't understand that expectation and know when it is that you're doing things right and when you're doing things wrong. So I believe, in effect, that the notion of expectation helps shape rights, but I think it does so in a way which can be systematized so that we don't have to think of it as, quote, a market without explaining what the property rights are. I think we can actually say that basic norm is that the physical separations between boundaries is a first approximation of an optimization strategy, but the moment you start getting with speech and information and everything else, the trespass rules break down in both directions, and now we try to figure out how it is we can optimize given the fact that we are dealing with things that aren't projectiles going over boundary lines. It's like the live and let live rule in nuisance cases.
So I think it's a good thing you made your comments, because you raised two issues that didn't come up clearly here. So one is that I alluded to this in my remarks, that I think that the question of government access to data is a different question, and one on which, as is very often the case in the Federalist Society, you see a certain division between the libertarians, if you will, and conservatives. And here, and it intersects with the second issue, where there is also a difference, which is about what I would generally call privacy fatalism. And basically, I think you've touched on both of those. I think your views are generally fatalistic about privacy. And I don't mean that to belittle them in any way, but you speak from a very common perspective. It has often been summarized as saying privacy is dead, get over it. I actually don't really fully share that perspective. I'm in some ways sympathetic to it. But when I have been talking today about user empowerment, I actually believe in the promise of technology to allow us to better manage our privacy. And I'll just two brief examples, and then I'll make a comment about rights. You talked about putting things in wireless transmissions and people giving up their expectation of privacy. When it comes to rights against government access, I actually don't think that should be the case. And I've devoted a large part of my time over the last year to supporting an effort underway in Washington to reform the 1986 law called the Electronic Communications Privacy Act, or ECPA for short, that intends to replicate Fourth Amendment protections for our data that is stored or held remotely by third parties. And that essentially fills in where the third-party doctrine has prevented the Fourth Amendment from operating. In other words, I actually think that for government to get data that is held or stored remotely that we might have otherwise kept in our private papers, or we might have in literal paper or on our home computer, the government should have to meet the same standards for getting a warrant that they would otherwise have to meet. And that's something where some conservatives might disagree, although the courts seem to be siding with me. But the second example is that I think actually something like Facebook, I understand where James is coming from in his comments about Facebook, but I actually am a little more sympathetic to Facebook in seeing that they're trying to keep up with a moving target. In other words, I like to believe that they are actually trying to build a system of user empowerment controls and essentially identity management. But it's an incredibly difficult task, and I think one that in many ways they have bungled in terms of how they've rolled things out and how they've announced things. But the problem of how you build controls to keep up with a moving expectation of privacy in evolving circumstances of interaction online is incredibly difficult. So I don't see that from a perspective of fatalism in saying that everything you do is going to be visible to anybody. I think there are ways in which you can empower users to make intelligent choices about, for example, in the recent controversy that we were talking about before the panel, about tagging photos of your friends. Facebook just launched a feature that automatically suggests, based on facial recognition, that you might want to tag certain friends in photos that you have just uploaded. And I think that, in many ways, is actually a privacy-enhancing feature, because when you tag somebody, you notify automatically that person that a photo of them is now on the site, and you provide an interaction for a social norm, like Professor Epstein is describing, to operate, because that friend can say, maybe that photo of me drunk last night is not appropriate, maybe you should take it down. That's a sort of interaction. But you have an evolving norm over time where I think privacy isn't perfect, but it doesn't mean that it's dead. And then finally, I would just say that about rights, again, this whole conversation we're having today largely comes down to two different conversations.
Bach the cut in the background.
Yeah.
Right. One is the private sector and how you regulate that, and that's mostly what I've been focusing on. And the other, again, comes down to limiting government access. And on the last point, I would just say that that's a very hard problem. And there is a perspective that comes from, I think, where you're coming from, that Stuart Baker has probably best articulated, basically saying that you can't functionally limit government's access to data, and you should instead limit their use of data, and you should audit how government officials make use of data very rigorously. And I'm not unsympathetic to that. And if you want a good short introduction to that, there's a chapter laying that perspective out in the book that we published earlier this year called The Next Digital Decade, which you can get online at nextdigitaldecade.com.
Great, thank you. Other comments? Yes, in the back.
how, if at all, does antitrust law play into this if a company or a group of companies sort of gang up on me? All right, so let's say I give Google information to the extent that I'm looking for music to download off a torrent site, and somehow Google ends up doing some kind of Google Books deal with music, and all of a sudden they've got a financial interest to tell the music companies that I just downloaded or at least searched for free music. What's to stop Google from doing that to me?
Nothing.
That if I put information into Facebook, again, Facebook values that control for the relationship with me. But I also value the control because I know that what rules Facebook does have, I can count on. I understand how this system works. I know how their privacy controls work. I know the information will not largely leak out of there. And Facebook actually has been involved in litigation with other companies that want to basically import in large volumes the Facebook's network of contacts and people's lists of contacts and their posts and all of that stuff from Facebook. So Facebook uses its terms of service to keep those other scrapers out. And this seems like, oh no, they're interfering with competition. They're preventing competition for the social network. But at the same time, if there was an open free flow of information, it's very hard to see how whatever privacy standards Facebook can insist on could be maintained. So in this respect, their refusal to cooperate with others plays a privacy-enhancing role.
And if I can just add to that, I agree with that, but I will say that I think going forward you're going to see this fact pattern being discussed a lot, and I would say that to the extent that companies do allow users to export their data, generally called data portability, so it's the idea that you could facilitate competition, say on terms like privacy among sites, by making it easier, lowering switching costs, by making it easier for a user to download their data and go to some other site. It's difficult because for the circumstance that James is worried about, I think, is probably the circumstance in which maybe somebody else logs in as me. So there's the access, the verification problem. In other words, the site, giving somebody access to their data and the ability to export it requires that you have a robust way of verifying that it's actually them. Otherwise, you create a huge privacy problem. But I would just say from an antitrust perspective in the future, I would hope that to the extent that sites make a valid effort, a genuine effort to do that in a privacy-enhancing, privacy-protective way to empower users to export their own data, as, say, Google has done with a number of its services. I actually think that should be recognized as somewhat of an affirmative defense in antitrust cases, for the simple reason that a company is really lowering the switching costs and making it very easy for me to say, look, if I don't want to use this site anymore, I can very easily go walk to your competitor. And so in that sense, I think privacy could play a role in future antitrust conversations in a way that I think is market enhancing and is not a regulatory mandate, but simply an incentive for companies to, in the right way, be a little more open and to facilitate competition.
By the way, this issue is not a new issue again. There was a case involving Bidder's Edge and eBay in 2000, 2001, in which exactly this scraping issue took place. And the Bidder's Edge people were essentially an auction aggregator who tried to get information from multiple sites so that if you wanted to buy and you saw something on eBay, you could compare it with something you got somewhere else. And what they tried to do is to get in through backdoor devices, which would allow them to scrape large amounts of data, put it on their view. And they said, look, we're perfectly okay because we're not doing the sale. You still get that transaction. And eBay won every one of those cases, and Bidder's Edge eventually, and companies like that went out of business. And their theory was, look, we have ways in which you could purchase access, and to the extent that you can now force your way in and take this data from us, you're depriving us of a reasonable revenue source. And in effect, what this is, it counts as a trespass for chattels. And this is even before that crazy Intel case, which they managed to muck up in the California circuit, because you didn't have the problem of whether there was tangible harm, given the fact that there was loss of revenue. And the trespass model essentially was one that was able to prevail. And you don't want to have somebody engage in competition in which they take the data of their rival and use it without the cost of production. What you want them to do is to be able to assemble the same data from public sources so that they can go into competition with those people who are already there. And in my view, what you typically see when you see these data sharing devices in mass portability is almost always they will be done by contract. It doesn't mean that there has to be cash payments. There can be reciprocal assets so that both bases get larger. And that would be on the analogy of patent pooling, for example, where a lot of information is gathered together with complementary resources without an actual cash payment, at least an explicit lump sum in one direction at the outset. So I think traditional resources are able to do that. And one other point is that standard law of trade secrets, including Seventh Circuit stuff, there's a very good Posner opinion, is you can create transfer of information to as many people as you want under vows of confidentiality, and you don't lose the trade secret character of this because you've gone from 10 to 100. And that's essentially what Facebook's model is trying to do, and they should be allowed to try and do that. And I don't know whether they're good or bad at this, but I mean, my answer to James is, if they really screw it up, there may be a breach of contract action in some of these cases, but I'm not sure that that's one that you're going to be able to win against.
And Judge Wood, if I can just clarify, just
what James
You can, and then we'll let James.
very briefly, I just want to clarify. We're talking about two different circumstances here. One is a circumstance in which some third party scrapes data off my service, and that's the trespass to chattels concept. The other concept we're talking about here is where the user says, I want to take my data and take it to some other site. And it may be that I take my data and do that through the service that's provided by that third-party site, but those are different fact patterns.
Oh, yeah.
So just to be clear.
James, did you want to?
No, I'm good.
Jonathan?
I'll happily forego any comment if we can have another question.
Okay, fine. Other, yes.
Mr. Burnham.
Let him have the mic.
Yeah, hi, my name is James Burnham. I learned everything I know in Richard Epstein's Roman law class.
Roman law of privacy.
But I won't ask about Justinian. I actually have a question for Professor Mazur. So opt-in and opt-out obviously does matter, and there's a lot to show that it does. I wonder if in the privacy area, having an opt-in regime might matter less than you think, because the information is so valuable that merchants and search engines would bargain for it in some way, like Dominic's does. And I think Professor Grimmelman was talking about that. They can't get the data on what you buy at the grocery store. So they have the discount program through which they then get all the data that they couldn't get otherwise. So I was just wondering if you think forcing that transaction might lead to a more efficient market where the privacy gets allocated in a way that maps better onto what people want without destroying the free flow of information that we currently enjoy.
So you say forcing that transaction, meaning
Opt-in.
choosing an opt-in system. No, I think you're exactly right. But I think that's the case for a lot of opt-in systems, frankly. I mean, you want to put the onus on whichever party you think is in a better position to evaluate the value of the information and to use it in a responsible way to be the one to compel people to get in. So certainly in the supermarket context, there are fewer people signed up for their local, rewards card than there would be if it were an opt-out system. We were all obligated to do so, and presumably the supermarket is investing exactly as much in marketing the program as it thinks is warranted given the value of the program. So I think that that's exactly right. It's sort of a common move across opt-in, opt-out systems to say which party is in the best position to evaluate what this information is worth, and then put the onus on them.
There's the other side to that, right?
Presumably, if you allow then the Dominics to have the control over the information, therefore to the no longer granting the credit card company essentially the monopoly control over that information, now you've imposed a cost on the credit card company. They have less incentive to offer whatever it is they're offering in their credit cards because they are receiving something of increased value. It's just, I mean, you've identified the benefit from potentially requiring an opt-in system here, but you forgot to identify the cost on the other side. And I don't know which way which one's higher.
Credit card system must be opt-in also, right?
No. I mean,
credit card shouldn't have an unfettered right to collect all this information.
We'll let Jonathan finish, and then we'll let Richard pop in.
So, I mean, the credit card system ought to be opt-in as well, right? The credit card shouldn't have an unfettered right to collect all this information about you, irrespective of what you want to do. And there are a lot of good reasons to think that the market won't be an adequate method of allowing people to select between these things. Because people don't know.
What we can say is that if they don't, the world will look different. And you're saying they shouldn't, assumes, therefore, that we're talking about a more efficient, more
Jonathan,
world. But I don't see how you can reach that conclusion.
there is a way to test this. We talked about antitrust. Diane said no Section 1, but she knows there's also Section 2. And
Rarely used, but it's there.
But this is the Section 2 question that comes out and puts the conflict between Jonathan and Jeff very explicitly. Suppose the credit card company sees this and it says, in fact, if we are going to supply you our services, then you must give us an exclusive with respect to the data, otherwise we're not going to take you. Or if it says, we will allow you and we'll ship you this data, but you have to pay us X dollars, will either of those two things, to the extent that they impede on the ability to create these buyers clubs inside the supermarket, will those things be antitrust violations or not? That, I think, is a harder question than others, and a lot of it depends upon your basic presumption. Jonathan would find a violation, Jeff would not, I suspect. and Diane would be sort of torn in between. And I haven't, I've worked in this industry a fair bit, and I have to say, the more I know about it, Jonathan, in some sense, the less I know about the way in which it has worked. I can tell you the person who knows least about this industry of anybody on the face of the planet, that's Senator Durbin, and his basic amendment, because he really doesn't understand any of the multiple functions that are associated with information collection and so forth. And the credit card business is a world unto itself because of its ability to have mass transformation of information. And even a simple question as to whether debit card users subsidize cash users or whether it's the reverse, which is swirled around the Durbin Amendment situation, is in fact a very difficult question to answer.
Well, these are difficult. Richard actually co-authored, I believe, an article with one of my former law clerks, Tom Brown.
Yes.
But the interesting thing in some ways...
He's a leader in this field now.
Yes, no, Tom, who has done excellent work in this field, and I commend what he's written to you. In some ways, you're looking at who's observing, right? You know, if the supermarket had enough people that they could post somebody at every checkout aisle to jot down, you know, you're buying these things today, they might be able to collect the same information. Phenomenally inefficient, they wouldn't do it. I mean, the present world allows them to collect things that are essentially public and observable. Maybe your credit card transaction is a little less observable. I can't resist saying, Richard, the last I knew, people, in fact, have a fair amount of competition with which credit card they decide to use. Yeah. They may pull out their Citibank Visa, or they may pull out their Chase MasterCard, and they pull out their American Express card.
You got it backwards.
Or whatever, you know. Chase has Visas, yes. I should know that. But in any event, there are a number of different cards. I guess Discover is still floating around out there.
American Express.
American Express. So there is competition, and the Supreme Court has said if there's competition at that level, then they're not going to worry too much about exclusives downstream.
I think that's right.
But
can I add something very quick to this?
Sure.
So I mean, in any sort of competitive market, there will always be opt-out possibilities, right? I can pay cash at the supermarket instead of using a credit card if I don't like the privacy implications of my credit card, or I can go search. You know, I can go online and search for a credit card that treats my information in more private fashion, if I cared about these things, which I don't. But the question is, for people who do care, are you going to get more intelligent, welfare-enhancing consumer decisions if you sort of either force them to opt for cash or force them to go online and try to figure out which credit cards are more consumer privacy protective than others? Or are you going to get more intelligent decisions if you institute some sort of opt-in, opt-out system that comes along with the credit card and is available in all these contexts? And I think there's a lot of market evidence that the latter will dominate.
I'd just like to add one thing to this conversation, which is true, I think, across all of the different markets that we've been looking at, is the presence of very strong network-related effects. We see this in the payment system, that there are values to being on a network that is widely accepted, and we see this very strongly with the social networking context, where you want to be on the network that has other people on it. And I think this is not a coincidence that we're thinking about what the privacy implications of individual choices are in situations where there is going to be a tendency to have external factors pushing you towards a larger network.
Yeah, can I comment on that? The question of what size network you want to be on, it is not correct to say that everybody wants to be on a larger network all the time. What it is that there are many people who do. But for example, when MCI came up, to give you, and this is an issue, if you're in the data transmission business and you're transferring financial data, what you will often do is have a dedicated system in which only you and other very narrow numbers of people can get on, precisely because the sharing is in the opposite direction. Facebook is a funny business because you want it open in one sense and closed in another sense. But in other businesses, the desire to keep the stuff closed, at least insofar as it goes through transmission, dominates, and it completely changes the form of industrial organization. And this, by the way, relates to something that Jonathan said, which I think is also instructive but wrong, which is there's nothing which says that patents dominate trade secrets. It is absolutely right that an advantage of the patent system is it allows you to make disclosures and to keep them marketed. But when people have valuable processes, there are trade secrets that are worth, $50 billion and so forth, precisely because if you put it on the market, and it is imitated or disclosed, it loses all its value. So we need both systems, and we make sure that the rules are clear enough, and then people can sort themselves in or out of these networks in terms of size, quality, and so forth. I don't think you disagree with that.
That's certainly true. I don't think I disagree with that at all.
But I mean, the way you said it, in effect, you made an advantage into a trump.
So as a longtime Federalist Society veteran, I've been involved with the Society for a decade. I've already done proper homage to the conservatives with my Burke reference, and I think I should throw in a Hayek one that seems on point to me, which is my favorite Hayek quote, of course, is that the curious task of economics is to demonstrate to men how little they really understand about what they imagine they can design. And that quote really, really fundamentally shapes my understanding of the privacy debate, in the sense that it's not enough to understand that we're talking about trade-offs here, which I think everybody on this panel recognizes. So when I was talking earlier about the conflict of visions, there are some people who won't accept trade-offs, but most people do. And the question then is how you proceed about them. And if I leave you with one thought today, it would be that it's incredibly difficult to really understand the trade-offs involved here, and how very difficult it is to get it right, not just because we're talking about new technologies that are difficult to understand, and not just because of the biases that I mentioned about underestimating the value that's lost by regulatory intervention, and so on, but also because fundamentally you have to look at all of this through the lens of Ronald Coase's work. In other words, every time we talk about the opt-in, opt-out debate, there is, to most people, and I don't accuse Jonathan of this, certainly, but to most people, to most people in Washington, to be sure, I think if you ask them, what difference does it make? They would say, well, in the end, sort of people have their preferences, and we're empowering them to express their preferences by either having an opt-in or an opt-out, and we'll get basically the same result. And anybody who has taken any amount of economics and studied Coase knows that that's completely wrong, right? And when I say that, I don't mean to say that necessarily argues in my favor, because somebody might say that, well, that's exactly the point. There are circumstances in which that's why it's so important to have an opt-in rule, because the transactions costs of effectively choosing mean that people won't make the right decisions. So that there might be circumstances like that. But by and large, what it means is that we have to be really careful in intervening, not just with opt-ins and opt-outs, but with something like do not track. So a do not track could be a valuable tool for expressing user preferences. I think James has the right idea that it's a way of making it easier for users to say what they want. But I worry that if the government gets involved in particular in trying to design that mechanism, you wind up with something that is not, in fact, terribly choice enhancing, because it's a crude tool. So the current iteration of do not track is a single one-size-fits-all. I opt out of tracking across the entire web. Mozilla, I've talked to them, they want to make it more granular, a richer experience. I think that's a great idea. But ultimately it comes down to this, which is that if you think that you're just going to get the same outcome because people can negotiate in the marketplace and the market will work perfectly, you're wrong, right? We will actually, the cost of setting up a marketplace for users to negotiate with websites to potentially pay for content and services is expensive. Now that expense might be worth bearing. We might be better off by having a marketplace where privacy-sensitive users can actually make that negotiation. But it's not going to happen overnight. It's going to be costly. And if you set the assumptions, as the Europeans want us to do, to be essentially opt-in assumptions. So for example, do not track is turned on by default for everyone, or do not track works in a very crude way as to be turned on for everyone by default, right? The costs are significant in terms of the value that's lost by websites that depend on advertising for their revenue, the data that's lost that could be used to generate other forms of wealth, as I mentioned earlier, in the form of speech and innovation.
Comment?
Brief comment, then we'll see if...
I disagree, I think, a little bit. I think there are two questions on the default provision and the comment on Hayek. On the default provision, if you get radio buttons, the switch is very easy to make one way or another. The difficulty is having enough information to decide which way you would like it to go, no matter which way the default turns out to be set. And that problem, I think, is actually the much harder problem in these kinds of environments for all the reasons that you say. The other thing is, I think it's wrong to say about the FTC report that it's default only. That's the lead edge. Let me just read you some of the headings. Proposed framework, and they say, companies should promote consumer privacy throughout their organizations and at every stage of the development of their product and services. That doesn't sound like talking about a default provision, does it? I mean, that talks about the way in which your businesses ought to run. And then they should incorporate substantive privacy protections into their practices. Companies should maintain comprehensive data management procedures throughout the life cycle of their products and services. This is much more intrusive if you actually read it on the line than the other thing, and that's what I'm always worried about, is that you use the default situation as a lever to come to the other thing. Also, with respect to Hayek, there's a sense in which the guy is completely wrong. I'm going to say that, not because of the socialist instincts that he had on national and stuff like that, which are true, but somebody has to be able to design something somehow. And when you start to kind of treat radical ignorance as the background condition, it means that you can't design a public road system any better than random. And yet there are principles for infrastructure design, organization, and taxation, which in fact can be organized and developed. And the problem that Hayek had is that when it came to figuring out how to organize the public sector, which is a pretty big part in this business, including network industries and common pool resources, he had absolutely nothing to say about it because his own sort of emphatic ignorance said decentralize all decisions, and private roads are not generally regarded to be an optimal solution. So if you look at him on whether you prefer special assessments, lump sum taxes, any of these kinds of really critical choices, he has nothing to say. And so I think that one has to be very careful before we praise him unduly about this stuff, because even though his instinct about decentralization when possible is correct, it's not always possible. And when that's the case, then you really have to figure out, can we have sensible principles? And a lot of 19th century law, for example, on special assessments, were debates as to whether or not it's market value or front footage and things like that. You've got to be able to answer those questions, and you can't simply say, well, let's leave it to the market. It's just not that part of the world.
I couldn't agree more. I'm a Mises man myself. So I think
he's worse.
Well, we'll save that for another debate. But I will say that the broad theme, of course, is not that planning is wrong, but the question is who does the planning and how. And without getting into the big questions about socialism and national economic planning, I would just take the example of do not track and these sorts of planning. My point is that I want Firefox to plan.
Me too. I'm with you on that.
Right. So in other words, what I'm arguing against is central planning by the FTC and especially by Brussels. And what I would very much like to see happen is to have the privacy controls be iterated and developed in the marketplace over time, and to recognize that that process is going to be necessarily messy. And so when Hayek says that we know less than we imagine we can design, I think this is a great example of where he was exactly right.
Because you can privatize this solution in a way that you cannot the roads.
Well,
I mean, and then when you get to the roads, if you can privatize them, it's the mistake. You can privatize them through the use of eminent domain power, for example.
But this is also different from the roads because we don't know what the roads here look like. This is not like saying.
I agree, it's different from the roads.
So here's what I would suggest to you. If you're interested in this point, Google the Firefox. I believe it's the privacy roadmap. So when anybody develops software, especially in the open source context, you have a roadmap of essentially where you think the features are going to go. And there are different roadmaps that they have for the different parts of their product. But the roadmap they have for how they think about privacy controls is really fascinating because it reveals just how little they know what the road is going to look like and how important it is to iterate in the marketplace and test. And so what I worry about is not just that the government would attempt to do that, because the FTC at least is smart enough to know that they can't quite do that. What the FTC thinks they can do is lean on the process and push it in a certain way. And it's that I think is so subtle and dangerous because they're leaning on Mozilla to essentially make decisions about, for example, having a tool that is broader, that has a default opt-out for everyone.
Well, I am going to not sum this up because that would be impossible, but perhaps leave you with a couple of themes that I think have come out. One of them is, are there any, background rules, aside from perhaps rules recognizing property rights and things, which since Richard is here, we will certainly acknowledge, that society has? I mean, the example was given much earlier about privacy and telephone conversations and the like. We've passed legislation that set some rules of the game against which everybody could operate. Are there any other such rules, or are we best off just saying, the market is going to move much faster than any kind of legislative or regulatory process? Maybe it's a time to step back, see how the market progresses, see whether private ordering does a better job protecting these kind of privacy interests, or are there some places where the government really does need to establish some background norms? And I think you've seen that there's a variety of view around those questions and many others. But should I turn it back to you, Trevor? Or
I would just like to give everybody on our panel a great welcome. And
well, thank you, everyone.